welcome to Crime in Court. This is episode number 89 of the Canton cover up, and we are talking about Commonwealth versus Karen Reed because there are new filings in the Karen Reed case, and we're going to go over those. So, there's four new filings. We're going to go over them very quickly. It's probably not going to be a very long stream because they're short. So let's dive in. Please hit the like button as we get started. So the first one I want to read through is the defendant's response to the Commonwealth's notice of scheduling, reassembly, and testing of defendant's Lexus telematics system. So in layman's terms, the state, the Commonwealth, has made a motion to do some more testing on the Lexus telematics system. It might be destructive, and that's why they needed to make a motion, and blah, blah, blah. All right, so here's Karen Reed's response to that. Now comes the defendant, Karen Reed, Ms. Reed, or the defendant, and respectfully files defendant response to the Commonwealth's notice of scheduling, reassembly, and testing of defendant's Lexus telematics system. As set forth herein, the Commonwealth's new digital forensics expert, Shannon R. Burgess, has opined that there were deficiencies in the chip-off procedure conducted by defense expert Maggie Gaffney, or Ms. Gaffney, on the defendant's Lexus infotainment and telematics system as a result of what he claims may have been programmer error. As set forth herein, Ms. Reed objects to the Commonwealth's position with regard to the to the new testing protocol as follows. Number one, defendant vehemently disputes Mr. Burgess's characterization of the chip-off procedure conducted by Ms. Gaffney, which is based on Mr. Burgess's fundamental misunderstanding of the difference between a megabit with a little b and a megabyte with a big B. And two, because Ms. Reed respectfully requests that the court adopt the protocol proposed by defense expert Matthew DeSorgra, who, for any future testing of the infotainment system and telematics system, which properly accounts for Mr. Burgess's misunderstanding relating to the storage size of the chips in question, and seeks to prevent further mistakes by Mr. Burgess, which could result in the unnecessary destruction of evidence. So, basically, this new expert for the state in his report or whatever he wrote up, he didn't do his calculations accordingly versus the megabits and the megabytes, and this guy's supposed to be an expert in this stuff and should have probably caught that. Somebody on X caught it. So we've got our armchair sleuths out there that are doing better than the experts that are hired by the Commonwealth. So there's that. All right. So, and any of this testing that may occur also could be destructive of evidence. So they don't want this Shannon Burgess, who doesn't know a bit from a byte, to go forward and do some destructive testing on it. Statement of facts. On October 11th, 2024, the Commonwealth filed the Commonwealth's notice of scheduling, reassembly, and testing of defendant's Lexus infotainment systems, requesting that its new digital forensics expert, Shannon Burgess, be permitted to engage in further, potentially destructive testing of Ms. Reed's infotainment and telematics system by conducting a chip-off procedure. The Commonwealth's request is premised on two opinions offered by Mr. Burgess regarding the analysis of the telematics and infotainment system associated with Ms. Reed's vehicle. One, that the evidence acquired in the December 2023 chip-off was incomplete and there is more data that was not acquired that exists on the chips. And two, that new hardware and software updates have been developed since the chip-off was conducted in December of 2023, which may assist in interpreting the data. highly qualified defense expert Matthew DeSogra, a licensed professional engineer and certified IPC specialist with Delta V Forensic Engineering Inc. So he sounds smart. Has reviewed the chip-off work conducted by Ms. Gaffney and opines that Mr. Burgess misunderstands certain basic digital forensics concepts. That is a burn, and I'm gonna highlight it because I liked it. Mr. Burgess misunderstands certain basic digital forensic concepts, including inter alia, the conversion of megabytes to megabits, negating certain of his opinions and necessitating that certain extra protocols be put into place to prevent programmer error by Mr. Burgess. Curriculum vitae for this Mr. De Sogra is attached. All right, so as set forth, Mr. Burgess's incorrect belief that the initial chip-off procedure failed to retrieve all of the data because of programmer error stems from his misunderstanding regarding the storage size of the chips in question. So he's claiming there's this data, somehow when they got the data in the first place, it somehow missed some data. It didn't transfer over some data, so that's why they want to do this retesting. But the data that they think was missing because of this megabyte conversion, it actually, if you convert the number, it's not missing anything. So it's not missing data in the data dump that we first got. Notwithstanding that fact, Ms. Reed consents to a chip-off procedure for the sole purpose of determining whether any of the updated software or hardware may assist in interpreting the data contained on the components in question. So she's not opposed to another chip-off procedure if it's going to see if there's any updated software or hardware. But other than that, I don't think she is she does not believe that there's missing data as this Shannon Burgess claims. So Mr. Burgess fundamentally misunderstands the difference between a megabit and a megabyte. This is so embarrassing, guys. Do your double check your work before you put it out there, especially if you're going to be in a court document. All right, so in his declaration, Mr. Burgess incorrectly concludes that the defendant's digital forensics expert, Maggie Gaffney, failed to extract all of the data from the two modules in the vehicle when she conducted the initial chip-off procedures in 2023. Mr. Burgess's opinions and conclusions are based on his incorrect belief and the prior chip-off procedure conducted by Ms. Gaffney resulted in 3 files totaling 8 megabytes in size, when they should have been closer to 64 megabytes in size on the total flash memory component of the chip in question. As explained in the attached declarations of defense expert Matthew D. Sogra, Mr. Burgess misunderstands the difference between megabytes and megabits. In point of fact, manufacturing speculations establish that the total flash memory component of the chips in question is equal to 64 megabits, little b, not 64 megabytes with a big B. Significantly, 64 megabits is equal to 8 megabytes. Thus, Mr. or Ms. Gaffney successfully acquired the 8 megabytes of data from the chips during the chip-off originally, which constitutes the total flash memory component of the chip in question. So if you do the correct conversion, you're not missing any data. Converting megabytes to megabits is a basic digital forensics concept which is critical to successful data acquisition and analysis. Mr. Burgess's failure to properly record the total memory capacity of the components at issue could cause the Commonwealth to seek and perform unnecessary destructive testing, which could, in turn, result in the unnecessary destruction of evidence. Accordingly, as set forth below, the defense respectfully requests that a defense expert be permitted to be present during any future testing conducted by the Commonwealth. We don't want you guys doing it by yourselves. We want to be there and we want to see the results ourselves, and that the defense expert be permitted to halt any testing and seek court intervention if Mr. Burgess makes any future mistakes, which risk compromising the data at issue. So they want to be able to intervene and say, okay, you're done here because you don't know what you're doing. Up next, defendants proposed amendments to the Commonwealth's proposed protocol regarding the examination of the infotainment and telematics system. New and updated Burla software, which did not exist at the time Ms. Gaffney conducted the initial chip-off procedure in December 2023, could potentially assist in decoding additional information from the Lexus infotainment and telematics system at issue. As a result, Ms. Reed requests that the Commonwealth be permitted to conduct further testing with oversight by a defense expert. The first step of any acquisition protocol is to properly record inter alia. That just means, among many other things. So it's proper to record and the memory storage capacity of the components the expert intends to test. So the Commonwealth's expert failed to do that here. As explained in the affidavit of defense computer forensic expert Matthew D. Sogra, which is filed herewith, we'll read that also. Throughout Mr. Burgess's infotainment data acquisition protocol, Mr. Burgess incorrectly reports the total memory storage of the components at issue. Ms. Reed respectfully requests that Mr. Burgess's proposed infotainment data acquisition protocol be updated as follows to prevent any programmer error during future tests. And a bunch of info that will go. I'm just gonna tell you straight up. It looks like it's hard to read with all these things. All right, so the expansion, whatever ending in 001, is a 64 megabit flash memory component. So these are all the flash memory components that they got when they did the chip off, I'm assuming. So the expansion is a 64 megabit, not megabyte flash drive or flash memory component. Notably, 64 bits is equal to 8 megabytes, which suggests that all available data was successfully retrieved during the first acquisition. The Micron is a 4 gigabit flash memory component, not 4 gigabyte, which notably 4 gigabits is equal to 500 megabytes, which suggests that all the available data, again, was retrieved. Now, this other one, the Micron ending in AEA, is a 2 gigabit flash memory component, not a 2 gigabyte flash memory component. So, notably, 2 gigabits is equal to 250 megabytes, which suggests that all available data was successfully retrieved during the acquisition. So, all of it matches up if you do the right conversion, which is a basic forensics function that he doesn't know how to do. Sorry, it's just a little funny that they put some shade on him, just a little. Additionally, Mr. Burgess proposes that he perform additional chip-off acquisition attempts to ensure complete data capture. This step is unnecessary because all available data was successfully retrieved during the first acquisition. In other words, the file size of the acquisition already matches the expected memory storage capacity of the components. Basically, the info that they retrieve, think of it like a flash drive, even though I'm sure it's different but similar in some ways. So think of it like a flash drive that you pull in and out of your USB plug. So if this is 2 megabytes, but he was saying it was whatever megabits and didn't do the math, then like it's impossible to figure that. I mean, I don't know. It's just crazy that this guy put this forth without doing that kind of math. Yeah. So they're saying, so like if it's a, use this as an example. So if I have a 2 gigabit flash drive, not gigabyte, then it would be notably 2 gigabits would be the same as 250 megabytes. So let's say this thing holds 250 megabytes, but I'm saying over here, here's 2 gigabits of data. It's the same size, but the Commonwealth is not doing the conversion, if that makes sense. Hopefully. All right. So additionally, Mr. Burgess proposes that he perform additional chip off. This step is unnecessary. Sorry, I read all that. All right. So, however, as explained by Dr. or Mr. D. Sogra, Mr. Burgess should conduct an acquisition to ensure that the contents of the memory chips have not been altered by confirming the checksum of the chips in advance of any further testing. An alternative proposed protocol for the examination of the infotainment and telematics system, which was prepared by defense expert Matthew D. Sogra, a licensed professional engineer and certified IPC specialist, is filed herewith as set forth in the protocol proposed by Mr. D. Sogra. The defense respectfully requests that defense expert Matthew D. Sogra be permitted to be present during any future testing conducted by the Commonwealth and be permitted to temporarily halt any testing if Mr. Burgess attempts to engage in any testing which risks unnecessarily compromising the data at issue such that the defense may seek court intervention. So this is so embarrassing. It's like, first of all, you got it wrong. Secondly, we want permission to basically supervise you because we don't trust you to do anything right. So we want the ability to stop you if we think that you're doing something that you shouldn't. It's awesome. It's a good, I mean, will Canoni allow it? I don't know, but hopefully. All right, so affidavit of defense computer forensics expert Matthew D. Sogra in support of defendant's response to Commonwealth's notice of scheduling, assembly, and testing defendant's Lexus telematics system. I, Matthew C. De Sogra, MS, PE, under oath, do depose and state as follows. I am a licensed professional engineer in North Carolina and certified IPC specialist. I currently work as a professional engineer with Delta V Forensic Engineering Inc. and specialize in chip and board level digital forensics. A copy of my curriculum vitae is attached here too as Exhibit 1. The following facts and information are based on my own personal knowledge, and I could testify competently thereto if called upon as an expert witness to do so. I declare that the following is true and correct to the best of my knowledge. This is new because I'm not even sure that we had this guy in the first trial. So these are both Mr. Burgess and Mr. De Sogra are both new experts coming into this. I have reviewed the Commonwealth's notice of scheduling, reassembly, and testing of defendant Lexus telematics system and proposed protocol prepared by Mr. Shannon Burgess. Certain statements set forth in Mr. Burgess's proposed protocol, which from the basis of his opinions are factually incorrect. In his analysis, Mr. Burgess misstates the memory storage capacity of the chips in question by failing to account for the differences between a megabyte, a megabit, a gigabit, byte and a gigabit. Yeah. All right. Like, did I say those right? Conversion between and among these units is a fundamental digital forensics concept which necessarily impacts data acquisition protocols and analyses thereof. I personally obtained and reviewed the manufacturing specifications of the chips at issue in this case. Mr. Burgess mistakes the memory storage capacity of the chips, which was removed they were removed from Ms. Reed's Lexus infotainment and telematics system. Again, I'm not going to read through it all, but he basically repeats the expansion is a 64 megabit, not megabytes, blah 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 blah. We're just gonna skip over that. Based on the above, I suggest that Mr. Burgess's proposed protocol be amended as follows. Step 1 of Mr. Burgess's proposed protocol, labeled Reattempt Chip-Off Acquisition, is unnecessary because the file size of the acquisition performed by Ms. Gaffney already matches the expected memory storage capacity of the component. So you don't have to reattempt to do a chip-off to get the information because you already have all the information you need. However, an acquisition may be conducted for the sole purpose of ensuring the contents of the memory chips have not been altered since the last testing by recording the checksum of the chips in advance of any new testing. So this guy's like, wait, wait, wait. Before you do anything else, you need to do this so that we can preserve our data, first of all. Then, defendant's expert shall be permitted to be present during any future testing or data acquisition conducted by the Commonwealth and/or its experts. And finally, defendant expert shall be permitted to immediately halt any testing that I deem place the data at issue to prevent the unnecessary destruction of data until such time as the defense can be heard before this court. Signed and sworn under the pains and penalties of perjury, 7th day of November. Matthew D. Sogra. So I think he understands his stuff a little bit more than this guy, than the Commonwealth's expert, especially when he's missing like a fundamental piece of knowledge, which is you convert your bits to bytes and whatnot. So, yeah, how he missed that, that's super embarrassing for that guy. I'm sure he's going to try to clap back and say, oh, no, 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 I did it right. But come on. All right, so now we've got the defendants. Um, Actually, I want to read this one first. Defendant Karen Reed's motion for relief from April 14th order to impound sidebar conferences. So, just from the sound of this, it sounds like they are trying to get the transcripts of their sidebars that were had during court that we as the public didn't get to see, but there still should be a transcript of those sidebars. So I'm thinking that, and they must have been impounded on April 14th. There was a motion in limine, it looks like. So let's read through this. All right, so now comes the defendant, Karen Reed, and respectfully moves this honorable court to release the transcripts of sidebar conferences that occur prior to and during the trial in this matter from the court's April 14th order of impoundment. So yeah, she decided to impound the transcripts before the trial even started. As for grounds for this motion, Ms. Reed states that evidentiary issues that arose during the first trial will be the subject of forthcoming motions in limine that will be filed prior to the commencement of the second trial, which is currently scheduled to begin on January 27th, 2025. We still haven't heard from Judge Cannoni yet. Remember, just recently, both sides, more so the state, wants more time, and they asked for a continuance until April 1st. We have not heard yet from Judge Canoni, if she's going to allow that or not. Without the ability to review the transcripts of those sidebar conferences and the rationale for the court's rulings, Ms. Reed will be unable to properly prepare for trial. Ms. Reed further states that good cause no longer exists for impoundment of the sidebar conferences that occurred during the first trial of or C Rule 7B. Ms. Reed further relies on the attached affidavit of counsel, which is incorporated herein by reference. On April 10th of this year, the Commonwealth filed its motion in limine for appointment of court stenographer, ongoing order to impound all sidebar conferences, and impoundment of juror names during trial. Attached here too is as Exhibit 1. The Commonwealth sought impoundment of the names of all jurors, all sidebar discussions, including sidebar discussions during pretrial proceedings, and that sidebar discussions and juror names be unavailable until a verdict is returned. Commonwealth's rationale was that the publication of matters discussed at sidebar, including jurors' names, information, and potentially sensitive responses to inquiry, while trial is ongoing, could prejudice the parties and expose jurors to extraneous matters. In its motion, the Commonwealth noted that after a verdict is returned, the partial prejudice to the parties will be greatly lessened, and that all parts of the record, except any that the court specifically finds subject to further impoundment for good cause, would then be available to the public. Legal standard Rule 7 of the Uniform Rules of Impoundment provides that a judge evaluating a motion to impound documents may enter an order of impoundment only if good cause to withstand documents from the public is shown. Or withhold, sorry, not withstand. To determine whether good cause is shown, a judge must balance the rights of the parties based on the particular facts of each issue. See Nixon versus Warner Communications. Where do I pick up here? It's all, sorry. I need to, I couldn't find where to keep reading. This is all gobbledygook. All right, so in making the good cause determination, a judge must balance the interest of publicity and a defendant's right to a fair trial. If there is good cause to impound documents, a judge is required to tailor the scope of impoundment order so that it does not exceed the need for impoundment. So even if there's stuff about jurors on there, you can impound that stuff, but don't keep the rest of it from being public because Karen needs these transcripts to prepare for trial. And it's very important that they do have it because Judge Canoni was so inconsistent in her rulings. So if there's any way to find some kind of a pattern or something about her rulings, maybe they'll be able to do that and benefit from that somehow. I don't know, but that would be my guess is that, she was so inconsistent and so um she didn't give reasons for why she ruled things a certain way. So a lot of times it was just, it's just what she says and that's what goes. Anyway, so let's keep reading. Once entered, an impoundment order remains an interlocutory order subject to the continued existence of good cause. Unlike other orders and judgments, an impoundment order carries no continuing presumption of validity to sustain it against a proper challenge subsequently brought. A party seeking the release of impoundment court records does not bear the burden of demonstrating either that there has been a material change in circumstances or that whatever good cause may once have justified their impoundment no longer exists. The burden of demonstrating the existence of good cause always remains with the party urging their continued impoundment. So if Mr. Lally wanted to impound the sidebar conversations in his motion in limine, he has to give a good reason as to why they should remain impounded. And that just means sealed from the public, in case you're wondering. All right, so a proper challenge to the continued validity of an impoundment order is raised whenever the party seeking to modify the order comes forward with a frivolous reason to do so. Once such a reason is before the court, the obligation of the motion judge is to apply the same balancing test used in determining whether to grant an impoundment order in the first instance. Here's the argument. Because good cause no longer exists for the order of impoundment to be continued with respect to the sidebar conferences, and because access to those materials is required for trial preparation, the impoundment materials should be released at a minimum to the parties. So even if you don't want to release them to the public, I need to see them. Me and my client need to review them. So the order of impoundment related to the sidebar conferences was entered by agreement on April 14th, 2024. The court issued a separate order of impoundment of the juror list on July 8th, 2024, and extended that order in response to an emergency motion by one of the deliberating jurors on July 18th, 2024. See findings and order on Juror Doe's emergency motion to extend that was the impoundment of the names of the jurors. In accordance with the July 8th, 2024 order and its indefinite extension on the July 18th motion to impound the juror names, the identities of the deliberating jurors in the first trial in this matter remain impounded. That aspect, the identity of the jurors, of the Commonwealth's April 10th, 2024 motion remains unchallenged here, as the issue of juror identities was subsequently addressed by the court. Ms. Reed instead seeks only the release of the sidebar discussions that took place during trial and those that addressed evidentiary rulings prior to trial. Evidentiary issues raised during the first trial in this matter were discussed at sidebar, to the extent that the Commonwealth was concerned that the release of sidebar conference transcripts during the pendency of the first trial could expose jurors to extraneous matters. Since the trial has concluded, the issue is now moot. As the Commonwealth noted in its motion, after a verdict is returned, the potential prejudice to the parties will be greatly lessened, and that all parts of the record except any that the court specifically finds subject to further impoundment for good cause would then be made available to the public. The court has found that the identities of the jurors should remain impounded until and unless otherwise ordered by the court. With regard to the discussions of evidentiary issues at sidebar, however, good cause no longer exists for impoundment. Good cause instead now exists for the release of those sidebar conferences, insofar as Ms. Reed's right to a fair trial is implicated in her ability to draft and litigate through motions in limine evidentiary issues that arose prior to and during the course of the first trial. Yeah, you got to look back at your record so that you know that you're not forgetting anything or whatever, like things that came up during trial that you might not think of. The issue of raising and being able to properly litigate evidentiary issues by reviewing in detail transcripts of sidebar conference discussions is non-frivolous and constitutes a proper challenge to the continued validity of the prior order of impoundment. In balancing the public's right to inspect documents against the defendant's rights guaranteed by the Sixth Amendment to a fair trial, a court may consider a variety of factors. These may include whether the information has already been disclosed, the nature of the documents under impoundment, or whether there are alternatives to withholding public access, such as a change of venue. There are, at this juncture, few aspects of this case that have not been explored in depth publicly. In fact, in its determination to continue the order of impoundment regarding juror identities, the court noted that the case has garnered significant and divisive attention in Massachusetts and across the nation. Use your own words right back in her face. I love it. In other words, virtually every issue in the case, especially following a completed trial, has already been disclosed. Factor weighs in favor of ending the previous order of impoundment. Another factor, the nature of the documents under impoundment, also weighs in favor of their disclosure. As noted, Ms. Reed herein seeks only release of sidebar conferences, not the identities of the jurors subject to previous orders. To the extent deliberating jurors could have been exposed to the extraneous information, the Commonwealth referenced in its April 10th, 2024 motion that concern ended with the jurors' service. They're no longer jurors. They don't need to be kept from the sidebar conversations. Additionally, there are few, if any, privacy interests implicated by evidentiary discussions at sidebar. The extent of the community interest also weighs in favor of the release of the sidebar conferences from order of impoundment, even while acknowledging the court's duty to minimize the effects of prejudicial pretrial publicity. Though Ms. Reed does not bear the burden of establishing that good cause no longer exists for the order of impoundment to remain in effect, and need not establish a material change in circumstances, she would be remiss not to mention that any good cause that did exist during the trial for the order of impoundment no longer does. The factors the court must consider in determining whether to continue its previous order of impoundment all instead suggest that the referenced sidebar conferences should be released at a minimum to the parties currently preparing for a second trial. Conclusion: for these reasons, Ms. Reed respectfully requests that this honorable court release any sidebar conferences that occurred during trial and any pretrial sidebar conferences dealing with evidentiary issues. From its prior order of impoundment, from its prior order of impoundment. Ms. Reed further requests that this honorable court rule on this motion administratively without the need for a hearing. So, signed David Yannetti and Alan Jackson. Oh, yeah, what do you guys think? I think they should. I think she should release the transcripts of the sidebars, but she made them sidebar so much for a reason because she didn't want things out in the public, so she's going to have a hard time, I think, allowing all of that. But I think just to give it to both sides to prepare without making it fully public, that's probably what she's going to do rather than give it to the public full access. All right, this is the last motion. It's the longest one of them all, so I guess this was a little longer than I anticipated, but here we go. So defendant Karen Reed's motion for discovery of communications in the possession, custody, and control of the Commonwealth. So you may remember that in the Turtle Boy story, we found out that uh, there were some ex parte or one-sided communications between DA Michael Morrissey to a couple judges after Turtle Boy was arrested, and they wanted him. Actually, it was before that, and they wanted. It was when Chris Albert and Jen McCabe and Colin Albert were all trying to get restraining orders on Turtle Boy. And at that point, when they didn't get the restraining order, and that's when DA Morrissey sent a scathing email to the judges saying this needs to be corrected and this has got to stop now. You know, his famous speech. So he basically committed some serious misconduct in his office. So this was on a personal email too. So let's not forget that. It was not his Michael Morrissey email. It was his, through the Norfolk County. It was his private personal email that he was emailing these judges on. So he knew that what he was doing was wrong because it was his personal email. So now comes the defendant, Karen Reed, and respectfully moves this honorable court, pursuant to Mass R. Crim P. 14A2, to order the Commonwealth to produce all communications made by the District Attorney Michael W. Morrissey from his personal email address and or cell phone that constitute material and relevant evidence in this matter, including but not limited to any communication with witnesses, i.e. statements of witnesses, and any and all ex parte communications with the court and or any other judicial staff concerning this matter. As grounds for this motion, recent reporting corroborated by documentary evidence demonstrates that DA Morrissey used his personal email address to communicate ex parte with Stoughton District Court personnel and judges. And this is according to NBC Boston. Turtle Boy's defense claims that DA lied about evidence improperly used personal email. In the publicly available email sent by Morrissey to Justice Stacey Forts, copying Massachusetts Trial Court Administrator Thomas Ambrosino, Justice Daley O'Malley, who presided over Karen Reed's case while it was pending in the district court, Philip McHugh, Deputy Court Administrator, and First Assistant District Attorney Lynn Beeland, who has now resigned at this point in time, which is also odd in timing. They lost Lynn Beeland and they lost their press guy, their communications guy, their PR person. Sorry, where was I? Oh, and all these people that he copied. DA Morrissey attached what appeared to be a text message or iMessage sent to a member of the prosecution by a witness in this matter that constitutes a discoverable statement pursuant to Massar Crim P 14. And that was a text from Jen McCabe saying she was horrified that Chris didn't get the restraining order. So then they weaponized that one statute and made him a witness intimidator through weaponizing a statute that was meant for people who are legitimately getting told if you testify, I'll end your life. That's witness intimidation, or I'll make things difficult for you. But he's not telling anybody to change their testimony. He's not making them testify one way or another. He's asking them to tell the truth, and he's just asking a lot of questions about them that they don't want to answer. And that's really the thing that they're so scared of. So the email and presumably a number of other communications that are material and relevant to Ms. Reed's case or constitute statements of witnesses are in the possession, custody, and control of the Commonwealth insofar as DA Morrissey of the District Attorney of Norfolk County, Ms. Beeland, is his first assistant, and both are members of the Commonwealth for the purposes of Rule 14. Accordingly, Ms. Reed respectfully moves this honorable court to order the Commonwealth to produce any and all communications by D.A. Morrissey that are discoverable under Rule 14, as well as any and all ex parte communications with the court and or judicial staff regarding this case. An affidavit of counsel is attached here too and is incorporated herein by reference. I don't have the affidavit, but probably say something similar. All right, so here is the factual background, and look whose name we see right there in the first sentence. On October 17th, 2024, attorney Mark A. Betterow filed a letter with this court directed to Norfolk County Special Assistant District Attorney and former Judge Robert Cosgrove. As we know, Attorney Betterow is one of Turtle Boy's attorneys in his witness intimidation charges. And he's basically been made famous by the Karen Reed case because everybody wants to hear what he has to say about it because he's just really brilliant. And he's now representing Aiden Carney, or Turtle Boy. And we've read through what there's been 3 separate letters. We went through each of them, the Betterow letters. And in each letter, the bombs just keep dropping more and more and more. So he's kind of like the truth bomber. He just bombs us all with some truths. And we're just like, whoa, because the way he writes is excellent. So in his letter, Mr. Betterow detailed communications between Ms. Jennifer McCabe and a yet unknown member of law enforcement, revealing that D.A. Morrissey had communicated on an ex parte basis with members of the Massachusetts Trial Court and Stoughton District Court, including the Honorable O'Malley. In his email, which Mr. Morrissey sent from his personal email address while copying First Assistant Beelan's office or official Massachusetts government email address, D.A. Morrissey detailed the fact that Chris Albert, another witness in this matter, had sought an ex parte harassment prevention order against Mr. Aidan Carney, which was denied by Justice O'Malley. Despite the fact that these hearings are public, D.A. Morrissey accused a member of the Stoughton District Court staff of leaking, quote unquote, leaking information about the harassment prevention order proceedings to Carney. Again, these are public proceedings and public documents with these proceedings, but supposedly we're leaking public documents? How's that even possible? D.A. Morrissey alleged that Mr. Albert's affidavit in support of his harassment prevention order was improperly disseminated to a third party. No, he could easily request it through a FOIA act. So that's, I mean, duh. These aren't protected. It's not a protected class of people, these McAlberts. Even though Norfolk County wants to act like they are, they don't have extra protection just because. I just don't get why they care so much about Alberts. D.A. Morrissey appended a text message or an iMessage to his email from Ms. McCabe, which reads, "I know it's late, but I am horrified that Chris didn't get it," meaning the restraining order. "And I am even more disgusted that the second time someone from the court leaked it right away to Mr. Carney." So because he got it right away and was able to talk about it on his channel, they were mad. Because he obviously, like, he's like, "Hey guys, I got Chris's harassment prevention order. Let's read through it and, make fun of it," because that's what Turtle Boy does. And of course, if you were trying to get a harassment order on Turtle Boy, you should have already known that about him. So, but there's nothing that he did that was illegal, and nor did he harass anybody. All right, so we know it's late, and we're horrified that he didn't get the restraining order. D.A. Morrissey directly referenced this matter, which he referred to as the Commonwealth versus Reed. Look at the spelling there. He spelled it R-E-E-D, meaning if there was a FOIA request or something and somebody got there, through, if somebody was somehow to happen to get Michael Morrissey's personal private email, he still changed the spelling of it. So when you type in Commonwealth versus READ, it's not going to catch it. You know what I'm saying? When he goes back to search, when whoever goes back to search and do a FOIA request for somebody, their names and things were misspelled, so you couldn't find it. He further notes in his email that the Commonwealth was informed by Mr. Albert and others that Mr. Carney had been provided with the harassment prevention order affidavit filed by Mr. Albert, indicating that the number of witnesses in this matter had contacted either the Norfolk County District Attorney's Office, the Massachusetts State Police, or another police department involved in this case. Regardless, the Commonwealth has vis-a-vis Michael Morrissey, through Michael Morrissey, acknowledged that it is in receipt of statements from a number of witnesses in this matter, which were apparently withheld from the defense. Without citing any specific statute, rule, or regulation, DA Morrissey opined that the receipt of an affidavit in support of a harassment prevention order by a defendant in that very harassment prevention order proceeding was completely unacceptable and must be resolved immediately, noting that the improperly disseminated court material being sent unsolicited to a third party, which is continuing to cause harm and damage to a witness in an ongoing homicide prosecution, must be a violation of court policies or a potential violation of law. DA Morrissey concluded his email by stating, I understand that you have to do an investigation and that may take time, but you also have to provide us with some evidence and assurance that you have taken action so we can safely continue to use the clerk's office in the Stoughton court. These people didn't do anything wrong. And he's like chastising them, like, we don't trust you now. Ay, ay, ay. All right, legal standard. The due process clauses of the federal Constitution and the Massachusetts Declaration of Rights require that the Commonwealth disclose to the defendant material exculpatory evidence in its possession or control. To be considered exculpatory and therefore subject to automatic disclosure, evidence need only tend to diminish a defendant's capability. A prosecutor's duty to disclose extends to all facts within the possession, custody, or control of a member of the prosecution team. The prosecution team generally is understood to include prosecutors and relevant law enforcement personnel, especially the DA who's behind the case, trying the case. Put differently, a prosecutor's obligations extend to information in possession of a person who has participated in the investigation or evaluation of the case and has reported to the prosecutor's office concerning the case. Mm, 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 mm. Our request, on request, prosecutors also must disclose material and relevant statements of persons within their possession, custody, or control. A statement is defined as a writing made by a person having percipient knowledge of relevant facts and which contains such facts signed or otherwise adopted or approved by such person, or stenographic, mechanical, electronical, or other recording or transcription of which is substantially verbatim recital of an oral declaration and which is recorded contemporaneously with the making of the oral declaration. Wow, that's a really long definition of what these statements of persons are that are discoverable. Any victim or witness statements in the possession, custody, or control of an advocate are subject to a discovery order. The prosecutor must determine whether the advocate's notes contain such statements. Prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to presumptive prejudice, and the drastic remedy of dismissal of charges may become an appropriate remedy. Argument. D.A. Morrissey's communications are within the possession, custody, and control of the Commonwealth and constitute material and relevant evidence or statements of witnesses pursuant to the provisions of Mass. R. Crim. P. 14. It is axiomatic that a district attorney himself is a member of the Commonwealth or the prosecution for the purpose of Rule 14 analysis. The use of a personal cell phone or email address does not shield otherwise discoverable information from production. But he didn't realize that. Or if he did, he just wasn't that bright about it. Mass. R. Crim. P. provides that the defendant may move, and following its filing of the certificate of compliance, the Commonwealth may move for discovery of any material and relevant evidence not required by subdivision within the time allowed by Rule 13d1. These Other rules require as mandatory discovery that the Commonwealth disclose material and relevant police reports, photographs, tangible objects, all intended exhibits, reports of physical examinations of any person or of scientific tests or experiments, and statements of persons the party intends to call as witnesses. The work product rule exempts from discovery those portions of records, reports, correspondence, memoranda, or internal documents which are only the legal research, opinions, theories, or conclusions of the adverse party of his attorney and legal staff. Rule 14 preserves the core of the work product doctrine by sheltering the mental processes of the attorney. The doctrine encompasses prosecutors' notes made in preparation for trial, including notes from interviews with witnesses. So we need your notes, Morrissey. Everything. Hand it all over. Preserve it, hand it over. According to whatever case this is. Proper preparation of a case demands that prosecutors assemble information, sift what they consider to be the relevant from the irrelevant facts, prepare their legal theories, and plan their strategy without undue and needless interference. This work is reflective in interviews, statements, memoranda, correspondence, briefs, mental impressions, and personal beliefs. There is no indication that anything in the publicly available email sent by DA Morrissey from his personal email address could reasonably be construed as constituting, constituting, constituting work product. So this is not work product. It's not safe, or it's not protected discovery. On the other hand, DA Morrissey's email includes a message from Jen McCabe that would constitute a statement under Mass R. Crim P 14 and which should be disclosed to the defense. As noted in the reporter's notes to the rule, prior informal statements not intended for court are not only admissible at trial, but often more probative than formal signed statements in anticipation of litigation. On this view, if the police have taken a statement of a witness who will testify, it should be discoverable to the defense. Wow, okay, well, there you go. And Michael Morrissey knows all this. He should know all this. But he's been so corrupt for so long that he doesn't play by anybody's rules but his own. As noted above, DA Morrissey appended to his email a message sent by Jennifer McCabe to a yet known member of the prosecution team that reads, I know it's late, but I am horrified that Chris didn't get it, and I am even more disgusted that for the second time someone from the court leaked it right away to Mr. Carney. Since this message was not included in the communications received by the defense in response to a Rule 17 motion directed to communications between Ms. McCabe and Trooper Michael Proctor, it was presumably received by another member of the prosecution team. Given the tone and informal nature of the message apparently sent late in the evening, it seems unlikely that this was the first occasion on which Ms. McCabe contacted this person. The communication further suggests some level of coordination between Mr. Albert, Ms. McCabe, and members of the Commonwealth in their decisions to seek harassment prevention orders against Mr. Carney. As also noted in this email, D.A. Morrissey told the recipients that the Commonwealth was informed by Mr. Albert and others that Mr. Carney had been provided with the harassment prevention order affidavit filed by Mr. Albert, indicating that a number of witnesses in this matter had contacted members of the prosecution team. Setting aside whether these communications constitute statements under Mass R. Crim P 14, subject to mandatory discovery on request, prosecutors also must disclose material and relevant statements of persons within their possession, custody, or control. Ms. Reed herein requests that any communications constituting statements of persons the Commonwealth intends to call as witnesses, so anybody, not just Jen McCabe, not just Michael Morrissey and Jen McCabe, but everyone that Michael Morrissey has spoken to in an ex parte fashion who may be called as a witness in Karen Reed's case. Disclose it. That's what we're asking for. Ms. Reed herein requests that any communications constituting statements of persons the Commonwealth intends to call as witnesses at the second trial in this matter be produced. A prosecutor is expected to actively seek out any exculpatory evidence held by the Commonwealth or another member of the prosecution team. A prosecutor's obligation to disclose exculpatory material is just that, an obligation, not a decision. It's not something you decide to do or not. It is something you are obligated to do by the law, by your sworn oath to uphold justice. I don't know why people forget that. As noted above, informal statements not intended for court are not only often admissible at trial, but often more probative than formal signed statements in anticipation of litigation. Furthermore, though a defendant need not make such a request to mandate disclosure, Ms. Reed requests that any material exculpatory evidence contained in D.A. Morrissey's private communications concerning her case, which is a matter of public interest, be disclosed. To be considered exculpatory and therefore subject to automatic disclosure, evidence need only tend to diminish a defendant's culpability. D.A. Morrissey's ex parte statements regarding this case are improper, not protected by any privilege, and should be produced to the defense such that it may determine if extraneous influence was asserted over members of the trial court or any other party related to this case. This is what I was waiting for. Do you think that Morrissey had these ex parte communications with Bev? Or with Jim, the clerk, who seems to be Bev's right hand man and may or may not have fixed the numbers in the little spinny thing so that the pro Karen Reed people were booted off of the deliberating jury. They were made to be alternates and told to just wait as an alternate. Could have been Jim that he was talking to and not Bev if he was trying to, like, I don't know. Could be either one. Could be more people that we don't know. And if I was any lawyer in Massachusetts, I'd be, or especially in the Norfolk County area, I'd be doing the same kind of request, trying to get to Michael Morrissey's personal email just to see what he's saying about my client if, I was representing somebody there. All right. So where was I? Sorry, I lost my spot. Any ex parte communication with the trial judge is contrary to the basic values of fairness governing litigation under our adversary system. D.A. Morrissey's ex parte communications with trial court justices, including the very judge who presided over Ms. Reed's case while it was pending in the district court, and his demand for evidence and assurance that action had been taken by the Stoughton District Court is extremely concerning. That's right, because he was like, we need to be reassured that you're taking action to correct this or whatever. Like, get the hell out of here. Michael Morrissey shouldn't be telling judges how to rule in certain cases. It's very concerning and raises concerns about the integrity of this prosecution. The judiciary's independence from the other branches of government and from outside influences and extraneous concerns have been one of the cornerstones of our constitutional democracy, intended to ensure that judges will be free to decide cases on the law and the facts as their best judgment dictates without fear or favor. The writings of John Adams preceding the drafting and adoption of the Massachusetts Constitution developed and articulated the essential linkage between judicial independence and impartial decision making. Judges' minds should not be distracted with jarring interests. They should not be dependent upon any man or body of men. To these ends, they should hold estates for life in their offices, or, in other words, their commissions should be during good favor, and their salaries ascertained and established by law. Thoughts of Government in Four Works of John Adams. Uh, okay, sorry, that was a citation. Since D.A. Morrissey cannot in good faith assert any work product or other privilege with respect to his ex parte communications about this matter, Ms. Reed respectfully requests that this honorable court order production of all such communications. Will Canoni do it? I don't know. She's probably one of the recipients of these emails, in my opinion. So they're gonna probably play some kind of game, like a hide the bad stuff and hand over what we can, which is, let's delete all the stuff that incriminates us. That's what I think is going to happen. It's hard to read through all of this crap. Da, 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 da. Any documents provided to the judge by the probation officers, this was from another case, should also be made available contemporaneously to the defendant, and any ex parte communication on substantive matters is strictly prohibited. Blah, 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 blah. All right, so basically, in conclusion, for the reasons above, Ms. Reed respectfully requests that this honorable court orders the Commonwealth to produce any and all communications by D.A. Morrissey that are discoverable under Rule 14, as well as any and all ex parte communications about or concerning this case. And that was also signed David Yannetti and Alan Jackson. And I sure, for one, would love to see both the sidebar, the transcripts of the sidebars, and see what those conversations were like and how Bev treated the defense team during those times. I would like to know because I just feel like she probably was very rude. And then I would also love to know um, who else Michael Morrissey has been emailing in his personal email. Do you think he's emailed Bev or Jim? Do you think he's emailed others about this case? I definitely think he's probably emailed Lolly about it. Like, you better get that mistrial if you don't get a guilty or something. I don't know. I really do think it was a coordinated effort to get them to a mistrial, the jurors, because I don't know how they would have ever convicted her on any of the charges, let alone uh, be hung up on that manslaughter one. I don't know. We will see what happens. Hopefully, we get some answers shortly from Judge Bev. Uh, Not likely because it's a defense request. If it was Lolly asking for something or Hank Brennan, the new attorney in the specially appointed prosecutor in this case now, if it was him, I'm surprised she hasn't written back and said, yes, granted your continuance to April 1st, because it was really a Hank Brennan motion, but the defense just basically kind of signed off on it because it doesn't hurt them to have more time to prepare. So, um, yeah, usually she will respond faster to the Commonwealth than she does the defense. So let's see how long it takes her to get back to them. We're still waiting also on the SJC. They just argued this week about trying to drop charges 1 and 3, or at least having the opportunity to call back the jury, which I think is probably what the SJC is going to have them do, but I can't really tell. We went over it in my last stream. Uh, there were some really tough questions on both sides. And that's the point, is they really try to pick apart your argument so that you stand by it, you argue it well, and see, whose argument was better in their minds. So we're waiting on the 7 panel jury for that to let us know if Karen Reed is going to be charged or tried for, yet again, charges 1 and 3, even though a jury acquitted her of that. And then, what else was I going to say? I don't remember. So we're waiting on that. Oh, and we're waiting on Bev's decision as to a continuance of the trial to April 1st. So that's kind of where it is. And then any responses to these. I would love to see Bev force Morrissey to hand over everything from his personal records, but I have a feeling she's going to protect that really, really tightly for some reason. Feel like I feel like she's one of the ex parte communications. It's just my opinion. I have nothing to back that up, but it would make sense, especially as to her nonsensical rulings throughout the trial. Um, and I'll leave you guys with that. I think Judge Bev is nonsense. She makes no sense. All right, guys, let me know in the comments below what you think. Do you think Judge Bev's going to grant any of these motions for the defense? What do you think the next steps are going to be? Let me know in the comments below, and please hit the like button on your way out. Thank you so much for watching, and I will see you guys in the next one. Take care.